Good afternoon, everyone. My name is Lluc Cerda. I'm the managing partner of the Calgary office of Samfiru Tumarkin. I'm the Western Canada employment practice leader, and we're here today to answer your questions related to employment law. Any questions you have about your rights at work, things that are happening at work that you're worried about, severance, termination, any of that, we're here to answer those questions for you today. So the way you ask that question, very easy. Just put it in the chat, and they will appear here on my end of the screen, and I will answer as many of those questions as I can for you today. So once again, my name is Lluc Cerda, and I'm here for the next half hour. So don't be shy. Put those questions in. We're going to try and answer as many of them as we can in the next half hour. I know probably a lot of people, what's on their mind is the news. Frankly, we are hearing now that the tariffs situation seems to be a thing. Tariffs, as you know, increase costs of doing business generally, and unfortunately may result in the economic outlook souring, which potentially results in job losses. So a lot of people are asking us, this is a very different situation. It's a little bit unheard of in our lifetime, a trade war. What does this mean for our employment rights? And what I can tell you is actually the situation is unique. Your employment rights remain the same. Okay. If you're terminated, you're still entitled to severance, even if the termination is as a result of the tariffs. If you are laid off, that amounts to a termination. All right. No employer in Canada has the right to lay you off unless you give them that right. All right. And you might have given them that right by agreeing that you can be laid off in your employment contract if you have one. Or you can agree to a layoff by signing their paper saying, I agree to this layoff. Anything short of that, potentially if you've been laid off before, then you've given the employer through your past practice, you've given the employer to lay you off again. But if that's not happening, if this is the first time you've been laid off at your employer, if you don't have an employment contract that says they have the right to lay you off, and if you haven't proactively told them that you agree that they can lay you off, then your employer does not have the right to lay you off for lack of work. All right, they are required to provide you with severance. All you have to do is ask. Okay, so if you need some help on how you go about asking for your severance, give us a call. You can reach out to us directly on our website at employmentlawyer.ca. You have the website right there on the screen. Feel free to reach out to us. We will be happy to speak to you, talk to you a little bit more about how your specific rights can be enforced and what your entitlements might be. All right, so questions are starting to roll in. Thank you guys for putting in your questions. I have a question coming in from Arpad Zabo. Arpad is asking, I am working for the company for 14 years. Can I receive severance pay if I'm terminated for refusing to sign a new employment contract while I'm on modified duty work? And is it legal to be fired? All right, a few questions there, all rolled into one. So if you're on, basically, an employer can't really impose a contract on you midstream. You've started working, certain working conditions, and I see it all the time. Employers say, we're just trying to make sure that our affairs are in order, that we have our paperwork, sign this employment contract. Be wary of that. That is not what's going on. Even if HR thinks that's what's going on, that contract is there to limit your entitlements, all right? That contract, you'll read it, it's going to sound one-sided because it is. It's a one-sided agreement that's there to protect your employer by taking away your rights, okay? Now, if you refuse to sign that contract, the employer has two choices. They can either continue to employ you on the terms that you had prior to them introducing this contract, or they can terminate you and provide you with severance. Okay. I don't think there's a world where they can say, well, because you didn't sign this new contract, we have just cause to terminate you. So they can't terminate you. Okay. So essentially, that's my answer to you, Arpad, is if you don't like the contract, don't sign the contract. Okay. If they terminate you, they'll owe you severance. If they terminate you, and the one of the reasons they terminated you is because you needed modified work, then that might open the door up for some human rights discrimination, some violation of your human rights, which entitles you on top of your severance to additional human rights damages. So all this to say, Arpad, is you should tread carefully here. I would suggest you have us take a look at that contract. Okay, reach out to us. We'll be happy to look at that for you. Okay, we're at employmentlawyer.ca. You got the website on the screen there. Reach out to us. We'll take a look at that contract for you. We'll get an idea of what's happening with this modified work and all of that, and we'll give you a course of action going forward, so you know that your rights are being protected. We have another question coming in from El Masoon. El is asking, my employer has reduced my commission structure. I work in sales and has given me 10 months notice, during which my pay remains unchanged for the period before the decrease. I have been with the company for 18 years. Once the 10-month notice periods end, can they terminate my employment without providing severance pay? I'm 49 years old and live in Ontario. That's a great question, El. So what happens, as I was just telling you, your employer doesn't have the right to change your employment conditions without your consent. You can refuse, and if you refuse, then your employer's option is to either continue on the old terms or provide you with severance. Now, a manner that severance can be given is as working notice. So instead of saying, here's, 24 months of pay as severance, we are going to tell you 2 years in advance that your job is going to end in 2 years. Or what they could also tell you is, we're going to give you 2 years notice, 2 years in advance, that at that 2-year anniversary, you're still going to have a job with us, but on this new contract. Okay. If you want to work with us in 2 years, you'll have to abide by the terms of this contract. All right. And now you have 2 years to think about it. Okay. And if at the end of the 2 years you decide I don't like it, well, the last 2 years have been essentially a kind of severance for you. You've gotten 2 years where you were able to receive your salary, 2 years where you were able to organize your affairs, try to find a better job, and move on. Okay. But you're someone who's been with the company for 18 years. You're 49 years old. I think that 10 months is probably a little light, frankly, on how much severance you'd be entitled to. Okay. So if you're looking to determine how much severance am I actually owed by my employer, I invite you to visit our severance pay calculator, which you can find at pocketemploymentlawyer.ca. So you've answered 2 of the 4 questions we'll be asking you, which is your length of service and your age. Actually, a third one as well, which is what kind of job you do, which is sales. So answer that one extra question, and we'll give you an estimate of what we think your severance entitlements might be. And if you see a big disparity there, which I think you will, between 10 months and what you're actually entitled to, I suggest you give us a call. Okay, because you want to get your full severance, not just the 10-month that they're offering you. Now, what I think is going to happen is at the end of this 10 months, El, they're going to say, okay, it's been 10 months. If you want to continue working with us, then you have to work on this reduced compensation structure. All right, we gave you 10 months to think about it, and now we're imposing it. All right, and you want to make sure that if that reduced compensation structure is not something you want to deal with or have imposed on you, that you receive your fair severance at that point. All right, and we'll be happy to get you to help you navigate that path to getting your severance. Okay, it can be a little bit tricky. That's why you get lawyers involved. Best to speak with us first so that you can make sure you're not saying the wrong thing or doing the wrong thing and protecting your severance entitlements. So reach out to us. Again, El, we're at employmentlawyer.ca. Reach out to us at employmentlawyer.ca, and we'll be happy to speak with you. We have another question coming in from S. Western. S. Western asks, I found a hidden camera at work after my boss was making claims that I had stolen from him. No one was told about the camera, and I was fired shortly after I found it. What are my rights? Depends, S. Western, where you're located. Based on your name, I'll suppose that you're in Western Canada, which is either, we can service employees working in BC, Alberta, and Ontario. Okay, BC and Alberta have privacy laws. Ontario doesn't really have privacy laws. So if you're BC and Ontario, you can make a complaint to the Privacy Commissioner. okay, which will investigate why there's a camera in that workplace. Theoretically, cameras shouldn't be in the workplace, especially cameras that are also recording sound, and especially cameras that are hidden. They should be well known. Now, there's some variants to that. So, cameras in a common area, such as a kitchen or a factory floor, might be more acceptable than cameras in a private office, or of course, you can imagine a bathroom or a changing room or something like that, right? But I think also what you're asking me is what can I do about the fact that I was fired? Now, I don't know why you were fired. Were you fired because this camera revealed that you were stealing? I guess probably not. But if you were fired because you were concerned, you made a complaint or had concerns about this camera, then that's generally not just cause. So if the employer terminates you, they have to provide you with severance. All right. Did they provide you with severance? And if so, how much? If they provided you with severance, then what I recommend that you do is check on our severance pay calculator if what you received is appropriate. If it's not appropriate, get in touch with us. We can help you get the right amount of severance that you're owed. How do you find the severance pay calculator? You have the website right there on the screen, pocketemploymentlawyer.ca. We ask you 4 easy questions, and we will tell you right away what we think your severance entitlements might be. And so that's in terms of lengths of months and how much money that ends up actually being for you. So visit that before you decide to do anything else. It's risk-free. There's no commitment that you need to make. That's information for you, so you know what you're doing here, what's at stake. Essentially, this is an important financial decision. I always tell people, you want to do it with the right amount of information. You got to do a little bit of due diligence. All right, so check that out. And if you were terminated for cause, what are they alleging? Right? I mean, if they caught you stealing, that could be a problem. I'll be honest with you. But if it's for something else, then I think you should want to speak to us. All right. So visit us, pocketemploymentlawyer.ca, so you have an idea of how much money we're talking about here. We have another question coming in from Brennan R. Brennan R. is asking, can an employer force you into a new position that they know you can't do because you have mobility issues, then fire you for cause because you are unable to perform the required tasks? Very interesting question, Brennan. And it's a question, unfortunately, that I see a lot. All right. Employers, employees, the workforce in Canada, we'll be honest, is not getting any younger. Okay. And the employees, as they get older, they develop, health issues, mobility issues, back pain, they need accommodations. And even if they don't need accommodations, the workplace is changing, new technology is integrated and all of that. And basically, someone who has been very successful in their role for many years, all of a sudden is given a new role, or there's a major change to their role. And all of a sudden, this person that's been a very successful performer in that company is not so successful anymore. And then the employer terminates them, saying that you're underperforming. Okay. And if that seems unfair to you, it's because it is. All right. So an employer, before they can terminate you for underperformance, has got to do a lot of work on their own side of the street. Okay. I can tell you, often see people that are terminated for cause, and I often see people that are terminated for cause due to poor performance. And I always tell them, poor performance is the hardest thing to prove for an employer. It's the hardest thing to prove, to establish just cause for an employer. Okay. Now, what I'm seeing here, Brennan R., is that you were in a position where it looks like you were successful. You needed an accommodation. They put you into a second position where the employer knew that you would not be successful. Remains to be proven. But definitely you didn't think you'd be too successful, and lo and behold, the reality is you weren't all that successful. An employer, before claiming that you're just not good at your job, has to put in the work, all right? They have to offer you some training. They have to set clear expectations, clear goals for you to to achieve. They have to give you an opportunity in terms of a length of time to achieve those goals. They have to warn you that if you don't achieve those goals, you may face discipline up to and including termination. And if, despite all of that, you still don't perform, then potentially they can claim that you're a poor performer and deserve to be terminated for just cause. What I often see, the problem is the employer does, checks all the boxes, they'll set a standard, they'll theoretically give you time to do the standard, they'll warn you if you don't meet the standard, you're going to be terminated, and then they'll leave you to your own devices, right? There's no training, there's no on-the-job coaching, there's no shadowing, there's no, mentorship. And all of a sudden, they haven't really changed anything but giving you warning letters, and then you're terminated. And they're surprised that you weren't able to succeed. It's not fair, and judges, I don't think, will view it as being fair either. And if it's not fair, it means it's not cause. And if it's not cause, you're owed your full severance, all right? And if you're wondering what your full severance is, if you've been here since the start of the show, then you will know that all you have to do is visit pocketemploymentlawyer.ca to figure out what your severance entitlements might be. If this is in any way related to the fact that you required an accommodation, you may also have entitlements to human rights damages as well. To get an idea of the full picture, I think once you figure out what your entitlements are, Brennan, I think you really need to get in touch with us. Talk to us a little bit about what's been happening. We can, chart a path forward so that you can get what you're owed, so that your rights can be protected. And if you're looking to speak to us, it's as easy as going to our website, employmentlawyer.ca. It's right there on the screen. Arpad is thanking us for providing an answer. My pleasure, Arpad. Thanks for joining the show. I'll let you guys know that if we don't get to all the questions today, there's another show tomorrow. My colleague Karen Terapowski is going to be on the show answering your questions. And we are going to try to get to as many people as possible today. But we have 4 shows this week, so you will have plenty of opportunity to ask your questions. My name, once again, is Lluc Cerda. I'm the managing partner of the Calgary office of Samfiru, Tumarkin, here to answer your questions related to employment law in BC, Alberta, and Ontario. We have another question coming in today from Canadian K, great name. I was approached by another employer to move to their company. After working there for 3 months, I was let go. I left a job of 2.5 years for the position. What are my rights in the situation? Seems to me, Canadian K, that you were let go because of during your probation period. I don't even know if you had a probation period, so everyone kind of assumes that there's always a probation period whenever you start a job. The first 3 months are probation. In fact, unless you have an offer letter, an employment contract that says the first 3 months are a probation period, there's no such thing as probation. It has to be agreed to. So a lot of this boils down a little bit, Canadian K, to what your offer letter says, what your employment contract says. Now, oftentimes I see this where someone is poached from another company. They've been at that company for a while. They have nice, secure employment. And then the new employer is promising the moon and the stars. Come work with us. You'll never be happier. You'll have a job till retirement. And then 3 months later, 7 months later, there's the door. And they come and they ask me, I was at this other company before, and I would have gotten a great severance had they terminated me. But I went to this new company. I've just been there a few months. Now I have no severance basically because I haven't been there very long. Well, that's not exactly true. Okay. Depending on what your contract says, Canadian K, and all of this is premised on is subject to what your contract says. But oftentimes we can use that period where you were at, this secure employment, kind of bring it in to your severance calculations. It's called inducement, is the legal term. You were induced away from secure employment and terminated after a short period of time. That can affect your severance entitlement. So instead of getting severance as compared to other people who were only there for 3 months rather, you might get severance as compared to someone who's been employed for 2 years, which can increase substantially the amount of severance that you're entitled to. Like I said, Canadian K, though, the big question mark, the big X factor here is, what does your offer letter say? What does your employment contract say? If you want us to take a look at that, we'd be happy to, and give you a more tailored idea of what your severance entitlements might be. So if you're looking to have that information, reach out to us, employmentlawyer.ca. Employmentlawyer.ca is how you can get in touch with us. We'll be happy to take a look at this for you in more detail. We have another question coming in from Rereg 7431. Rereg is asking, my father's employer has told him that they will be retiring him at the end of the month. Is that allowed? Well, short answer, long answer is the same. They're not allowed to retire your father for it. Okay. If they retire your father, they're essentially terminating your father. If they terminate your father because he's too old, number one, that's not cause, so he's owed his full severance. Number two, that's probably age discrimination, so he might also have severance entitlements. I recommend that your father reach out to us sooner rather than later. Okay. Definitely, what we tell people, if your employer is going around asking, what are your retirement plans? When are you going to retire? I recommend you tell them, listen, I have no plans to retire. I'm a healthy individual. I love working. I'm going to be here till I'm 90. Right? I don't need to retire. I don't plan to retire. Don't think that I'm going to retire. I'm here for the long haul. And then if they want to terminate you, then they can terminate you with your full severance. And if they're doing it for discriminatory reasons, then they need to know that, that's going to open them up to potentially exposure for human rights damages, because discrimination on the basis of age is not allowed in Canada. All right. So like I said, I think it's important, but your father's been with the company for a long time. Everyone's being nice to him. He's going to go along to get along. And then next thing you know, he's out of a job. He's got no more salary coming in. He's got no severance, but he's got a nice card, right? No, right? He needs to make clear he does not want to retire. He is not retiring, okay? That's what he needs to tell them, and we can help him do that. If he wants to speak to us directly, he can speak to us. Just reach out, employmentlawyer.ca. And we'd be happy to speak with your father. All right. We have another question coming in from YYZ. YYZ is asking, can an employer terminate your employer if extended family caregiver leave, if you're on extended family caregiver leave? So there are certain leaves under employment standards. I take it, YYZ, that you're in Alberta. So there are certain leaves that are in job protected leaves under employment standards. Okay. Those are the minimum amounts of leaves that people are entitled to. Okay. So those leaves are for a certain amount of time. Okay. And those are job protected leaves. That means that your employer can't terminate you for taking that leave and has to put you back in your job at the end of that leave. Those leaves are not necessarily very long, right? Now, if you have extended beyond what the employment standards provides, because you have to provide caregiving to a family member, then you may also have protections under human rights legislation. Okay, so under human rights legislation, you can't be discriminated against due to your family status. All right. What that means in the employment context is if you have family obligations that require your employer to accommodate you, then your employer has that duty to accommodate you to the point of undue hardship. Now, it's a bit tricky to get this leave. It's not just so that you can take your kid to hockey practice at 4:30. Okay. The requirement, the family obligation that you have needs to be a serious one, and it needs to be one that can't be done by anyone else. All right. So using this example, yeah, basically, if your kid needs to get to hockey practice, but you need to be at work, your kid needs to figure out how to get to hockey practice by other means, or needs to drop hockey. Okay. But if your kid needs to go to, God forbid, chemo appointments or something like that due to their health, and you are the only caregiver that can take them because maybe you're a single parent, maybe you don't have extended family in Calgary, right? You're from abroad or something, and it's just you and your kid, and you don't have friends that can take them. And basically, if you don't take them, your kid's not going to chemo, right? In that case, you've tried your best. You can ask your employer, listen, I need some time off to take my kid to chemo, right? And your employer has to accommodate you to the point of undue hardship. Or, your kid after school programs end at 4:30. You need to be at school at 4:30 to pick up your kid, because or else, they're out by the school all by themselves in the middle of the winter. That's not good, right? So you have to be able to leave early, go pick up your kid, right? In that situation, you've checked if there's after school daycare, there's nothing, if there's, any kind of program, if there's a grandma, if there's something else, you can hire a babysitter. None of that is available to you. You have to be the one to go get them. Then your employer has to accommodate you. So what I'm seeing here is extended family caregiver leave. So I don't know if it's you're caregiving extended family or you need an extended leave. So obviously, if it's the closer the relationship is to you, the easier it is to justify that you need an accommodation, YYZ. So if it's your child, if it's your spouse, if it's your parents, right? If it's your aunt, does your aunt have a husband or children that can take care of her? Is there some sort of long-term care home that they can be in or something like that, right? That's what you have to ask for yourself first before you go and ask your employer, I need more time off, okay, frankly. So you got to try your best to see if you can have someone else do the caregiving so you can be at work. But if you can't, then you can go ask your employer for a leave, and that is protected under family status. Okay. This was a very long-winded answer, I realize, YYZ, and I hope you understood what I'm saying. But if you didn't, reach out to us, okay? employmentlawyer.ca. We will go through these questions. Who else can help and all of that with you to help you determine whether you have protections under family status under human rights legislation, okay? All right, we have a few more questions. I'm going to try to get through them as quickly as possible. As I said, if I don't get to your question today, we have another show tomorrow, all right? So you'll be able to answer your questions tomorrow, to have your questions answered tomorrow, but I'm going to try and answer the ones I have here today. We have a question from Laura Bia. Laura Bia is asking, what about working for a U.S. company as a Canadian remote worker? Will all of the problems impact severance? So if you were here since the start of the show, you heard, Laura, that we are in unique times, but it doesn't affect your employment rights. Your employment rights remain the same, all right? So if you are terminated because of the tariff war and all of that, you still are entitled to severance pay. What's interesting about your case is you're a remote worker in Canada working for a U.S. company. So if you're in BC, Alberta, or Ontario, you are likely going to be treated under Canadian employment laws, okay? And under Canadian employment laws, you have an entitlement to severance if you're terminated on a without cause basis, okay? So if things get a little bit rocky over the next few months due to all of this turbulence, first thing you do is reach out to us and contact us at employmentlawyer.ca. We can help you navigate this. And if you are wondering, well, if I am terminated, what are my severance entitlements? Go take a look at pocketemploymentlawyer.ca. That's where you'll find our severance pay calculator. You answer 4 easy questions and you'll get our estimate of what we think your severance entitlement might be. All right. Time for our very last question. Thank you all for joining today and for your great questions. I'm going to finish it off, last but not least, from this question from YouTube from Errol Gray 22. I was recently put on a layoff and told that because of the industry I work in, this is normal. Is it true that certain industries have the right to lay off a staff, or is this a lie? I work in the trades. Very interesting question. So it's partially true that if your employer can demonstrate that there is a custom in your industry, that there are layoffs, then that is presumed that you also know this, and therefore you agree to the layoff. Okay. I say if your employer can prove there is such a custom, it's hard to prove. It's not because you're in the trades that it's automatic. We often see in trades that there are seasonal layoffs. Doesn't mean that because there are seasonal layoffs, you can be laid off just whenever. I don't know how long you've been there, but if you've been there for over a year and you weren't impacted by any seasonal layoff, then that really makes it hard for the employer to prove that there's seasonal layoffs in your industry because they didn't do it last year, right? So it doesn't seem like this is something that happens all the time. So I would tell you, Errol Gray 22, that it is theoretically possible. It's very hard for the employer to prove. If you've been laid off and you think and you don't agree with that layoff, and it's not in your employment contract that the employer can lay you off, and this is your first time being laid off, then you can treat the layoff as a termination. So give us a call, write to us, and we will be happy to go through these questions with you, and we'll let you know what your severance entitlements might be and how we can go about getting them for you. All right. So that's the time we had for you today. Thank you so much for your participation. Some great questions, as always. Love hearing these questions from all walks of life, all across Canada. My name is Lluc Cerda. I'm the managing partner for Samfiru Tumarkin, for the Calgary office of Samfiru Tumarkin. I'm the Western Canada employment practice leader. My pleasure, as always, to spend the last half hour with you, and we will talk to you soon. Thank you.